And good afternoon, everyone, and thank you for joining us for today's legislative update webinar focused on recent COBRA and Department of Labor changes. My name is Scott Harris. I'm part of the Labasco Consulting Group team, responsible for creating greater brand awareness of our firm and helping to match opportunities to assist our current and prospective clients with their employee benefit matters. Labasco Consulting Group designs, implements, and manages employee benefit programs within 3 areas of expertise, all centered around the employee. These include health and wellness benefits, retirement plan consulting, where we act as your advisor and plan fiduciary, and executive benefit consulting, where we implement non-qualified plans and other insurance products for business continuity and succession. Joining me today are my colleagues Mike Labasco, Executive Vice President, and Aaron Loisel, Managing Director of our Employee Benefits Practice. Now let's talk about Kerr Russell. Kerr Russell is a full-service law firm based in Detroit and was founded nearly 150 years ago. The firm supports businesses on matters including business and corporate law, labor and employment, immigration, data privacy, healthcare, litigation, intellectual property, construction, surety, real estate, and tax. Today, we're going to focus on employment-related matters, in particular, recent COBRA and Department of Labor changes and how these impact your business. And with that, I'd like to introduce our 2 featured presenters. Liam Healy practices in the area of business law with a focus on employee benefits and ERISA. Liam specializes in designing pension and executive compensation plans to benefit business owners and executives. He also advises clients on compliance, correction, procedures, and audits. Mark Knoth chairs the firm's labor, employment, employee benefits, and ERISA practice group. He counsels and advises business owners, managers, and human resource professionals on many workplace issues. Mark is experienced in both labor and employment policies and represents employers in investigations conducted by the EEOC, the Michigan Department of Civil Rights, the Department of Labor, the Office of Federal Contract Compliance Programs, and the National Labor Relations Board. In the last 12 months, COBRA provisions have changed 4 different times, with the American Rescue Plan Act of 2021 representing the most significant of those changes. I look forward to hearing Liam and Mark explain these changes in greater detail today to benefit all of us. And with that, I'd like to turn it over to Liam Healy. Liam?
Thank you, Scott. Hello, everyone. Thank you for attending today. My name is Liam Healy. As Scott mentioned, I'm a business law attorney at Kerr Russell with a focus on employee benefits and ERISA. I don't have to tell you that there have been many changes in this area of the law over the last year, with the most recent change, of course, being the American Rescue Plan Act and the COBRA subsidy as provided in that act. And that is what we're going to talk about today. So let's dive right in. So the American Rescue Plan Act was signed into law by President Biden on March 11th. It provided significant provisions for relief, both to individuals and businesses, in the form of stimulus, unemployment benefits, tax credits. The COBRA subsidy is contained in 9501 of the Act, and this represents a 100% subsidy for COBRA premiums as paid by employees. Now, of course, the Rescue Plan Act has some interaction with other law. It is an overlay of COBRA. The regular COBRA rules apply. The COBRA exemptions apply. other requirements apply. There is some relationship with paid family and sick leave credits. Specifically, first of all, there is a provision for a prohibition of double benefits, which we'll talk about later. But there's also a tax credit which will resemble, particularly in procedure, the manner in which the employer can be reimbursed for the subsidy. Finally, there are similarities to a previous COBRA subsidy under the American Recovery and Reinvestment Act of 2009. And while we await further guidance, which we expect shortly, we believe that the ARRA provisions do provide some insight into the way that this subsidy will work. Next slide. And of course, there is a series of notices, the first being 2020-1, which was issued in early 2020 in response to the pandemic, and it provided a suspension of various deadlines relating to employee benefit plans, including COBRA elections and COBRA elections themselves, and then the notices. The original period for the suspension was beginning March 1 and continuing until 60 days following the nationally declared emergency deemed the outbreak period, quote unquote. Of course, that has never come to be to date, and so the problem with that notice was that it's based on a part of the tax code and ERISA, which limits that sort of suspension of deadline to a 1-year period. So additional clarification was required. That was issued in February of this year, 2021-1, and basically it is the suspension period in general is being applied on a case-by-case basis. So rather than the expiration taking place end of February 2021, it is based on an individual's qualifying event. So it will be either 1 year following the qualifying event or 60 days after the end of the outbreak period, whenever that is declared. And so the question is, how does this set of notices relate to the COBRA subsidy? How will that affect the deadlines under the COBRA subsidy? We're waiting for guidance, but we'll talk a little bit more about that shortly. So the effective date for the American Rescue Plan Act and the COBRA subsidy in the Act, the date of enactment is March 11th, as I indicated. The effective date for the COBRA subsidy is defined as the first day of the first month after the month of enactment. So the subsidy period is April 1, 2021 and ends September 30, 2021. That is a maximum period of subsidy. You'll see that there are events that can cut that short, which we'll talk about. The date of enactment is distinguishable. So certain deadlines are based on the date of enactment, and others are based on the first day of the subsidy period. So we'll talk a little about that as well. Next slide, please. So who does this benefit? Qualified beneficiary generally benefits from COBRA, but an assistance eligible individual under the Act, or AEI, is defined as someone suffering a termination of employment or reduction in hours resulting in loss of coverage. Now, it should be noted that the other COBRA qualifying events do not apply for purposes of this subsidy. It's limited to the qualifying event of termination of employment or reduction in hours. It's the paren 2 qualifying event in the various provisions in ERISA and the code. So that's important to keep in mind. No disability, no divorce, other qualifying events are not relevant. Now, for this purpose, it has to be involuntary, which of course is not the case with this qualifying event under the normal COBRA rules. And so that's an issue. We'll talk a little bit about what that means. No gross misconduct. That's a typical exclusion that does not provide for a qualifying event under the regular COBRA rules. Importantly, the continuation period must overlap with the subsidy period. So an AEI is defined as someone that is entitled to COBRA under the regular provisions as modified, as we just discussed, but in the period of subsidy as defined in the Act. It can include others than the employee themselves, as is normally the case. Next slide, please. So what is involuntary? There was a notice relating to the American Recovery and Reinvestment Act, and there were some FAQs, and the issue of what rises to the level of an involuntary termination, which was also a requirement in that legislation, is covered. Now, of course, this is non-binding because this is old guidance and it relates to a totally separate piece of legislation. But while we await further guidance, it may provide some insight. There's certain terminations which are obviously involuntary, but there's going to be others where it's going to come down to the circumstances. And under the old guidance, it was a facts and circumstances test. So we have to be mindful of that in determining whether or not termination is involuntary and therefore leading to eligibility. So you might have a constructive termination situation. You may have a forced retirement situation, and so that has to be examined. And this previous guidance might provide some clues. Next slide. So it helps to think of three basic groups of AEIs for purposes of the timing of election relative to this subsidy period. You have employees that are receiving benefits under COBRA as of the first date of the subsidy period. They're going to continue to receive those benefits, but they're going to be deemed to have paid the premium through September 30th or whenever they are no longer eligible, if earlier. So there's that group that just continues they're already receiving COBRA that continue to receive it as of April 1. Then you have an employee having a qualifying event on or after April 1. So a new COBRA eligible employee or former employee. That's a second group. And then you have this third group, which are people that had a qualifying event before, and either they didn't elect COBRA because it was too expensive or for whatever reason, or they elected COBRA but they stopped paying premiums at some point, and that's a third group. And we'll talk more about how they're treated in a minute. Next slide, please. So for the first group, there's no election required. They've already made the election and they're already receiving COBRA. They will receive a notice, which we'll talk about in a minute. Those new folks that have a qualifying event after April 1, the normal election rules are going to apply. They will receive a different notice than they otherwise would have, which again we'll talk about. There's a separate provision in the American Rescue Plan Act, so COBRA subsidy, which provides an extended election period. And this is for the third group that had a qualifying event at some point in the past. And again, they didn't elect COBRA or they stopped paying the premiums, and the event is outside of the subsidy period. They are still entitled to COBRA, and they would elect that coverage in a period beginning on that first day of the subsidy period and ending 60 days following receipt of a notice. And so this is the extended election period that is is provided for in the Act. Again, we'll talk about events that could cut that subsidy period short, but under the depending on the circumstances, the point is there are people that may have suffered a qualifying event long before and still be entitled to some subsidy in the subsidy period. So this is an example, and this is kind of the outside example. Employee A actually suffers a qualifying event at the end of 2019. But given the 18-month COBRA eligibility period, they may have a very short period in the subsidy window where they could receive the subsidy. So their 18th month would be April 2021, and they would elect that subsidy within that window, which is starting with the first day of the subsidy period and ending 60 days after whenever they receive the notice informing them of their right to elect this subsidy. Next slide. So this deals with the fact that the subsidy period of April 1 to September 30 is the maximum period. And so you may have events which cut that short. And these are the three events. If you, as a recipient of the subsidy, are covered by alternative group health plan, either a spouse's plan or otherwise, or you become eligible for Medicare, you are no longer eligible for the subsidy. Furthermore, like in the previous example, if you reach the end of the 18-month maximum period of COBRA eligibility within the subsidy period, you're no longer eligible for any additional subsidy. And then if earlier, September 30, the end of the subsidy period. Now, an AEI that becomes ineligible by being covered under an alternative group health plan is required to inform the plan of that ineligibility. We're waiting for guidance as to what that will look like, whether it's a form or notice, but there are penalties stated in the Act if the COBRA recipient fails to do that. In addition to electing underlying coverage, there is an option stated in the Act that an employee can switch coverage. There are certain requirements, but if there is a qualifying event, the AEI can essentially take advantage of alternative coverage under the plan. It has to be different from what they're enrolled in. It has to be elected within 90 days of the notice of the option. And there are additional requirements on the next slide. So this is the one part of this COBRA subsidy that is optional for the employer that is covered by COBRA, and that is whether or not to provide this option. So it's not mandatory, but if the option is provided, it has to be honored. The premium cannot exceed the applicable premium for the existing coverage that the recipient had prior to the qualifying event, and it has to be offered to the same class of employees. And it cannot be one of these forms of coverage below an accepted benefit. It has to be major medical like the previous coverage, and a QSERA or a flexible spending account is not not considered alternative optional coverage that can be elected by the former employee. Next slide. So let's talk about the notices. This is important, obviously, for the employers. There is a deadline for providing these notices that is based on the first day of the subsidy period. So, like other notices, it has to be clear and understandable to your average employee or participant. If you don't provide the notice, you're non-compliant under COBRA. It has to state that a subsidy is available. It has to describe the coverage option if the employer decides to offer that. It has to include forms, and obviously this is something we're waiting to see what it will be provided by the departments in terms of forms to elect the subsidy. It has to provide contact information, either the plan administrator or another party that has been assigned responsibility for this procedure. It has to describe the extended election period for that group that may become eligible. It has to talk about the fact that the recipient, once ineligible, must inform the plan, and that there are penalties for not doing so. And then it has to make very clear that this subsidy is available. So the employer can modify their existing COBRA notice, but this is a limited duration subsidy. So it kind of depends on what model notices will be provided by the departments. But there can be a standalone notice. You can modify your existing COBRA notice. You can have multiple notices because there are different purposes for these notices. A couple of different varieties of notices, as we'll see a little bit more. Now, the model notice, the Act requires the DOL to provide model notices fairly quickly. So we should have models by April 10th, but it has to be provided by the employers by May 30. That's the 60-day period specified in the Act. Next slide. So the notice of extended election period, this is what we had discussed before in that example. I mean, in theory, this could be a separate notice, but it may simply be baked into the existing COBRA election notice. But it has to describe the fact that a former employee with a qualifying event falling outside of the subsidy period has this sort of second bite at the apple, so to speak. Next slide. In addition, you have to provide a notice of expiration. And there's a separate window for providing this notice of expiration. So not only do you have to, as an employer, determine who might be eligible under that extended election period, you also have to determine when everyone will no longer be eligible for the subsidy within the subsidy period. And you have to provide notice of that within a window which is no earlier than 45 days and no less than 15 days before the date of expiration. The notice has to prominently describe the fact that your coverage is the subsidy will be ending soon, and the date. And then you have to describe alternative coverage, which might be you're still eligible for COBRA, but the subsidy is ending, or other coverage. Now, there's no requirement that the notice be provided if the COBRA recipient or the subsidy recipient becomes eligible for alternative coverage under a group health plan through a spouse or otherwise, because remember, they have to provide notice to the employer, and so this notice of expiration is not required in that respect. Or in that instance, the DOL has a little bit more time to provide that model notice, but it's expected at the end of April. So moving on to the tax credit, the employer is reimbursed for the 100% premium that it is paying on behalf of the COBRA recipient. The Act talks in terms of a couple of different groups that might be entitled to the credit. So if you are dealing with a multi-employer plan, it's not the separate employers that are part of the plan that receive the credit. It's the plan itself. But in general, if you have an employer that's covered by COBRA and not part of a multi-employer plan, they are entitled to a tax credit, and that credit is applied against the employer share of the 311B Medicare tax. This is a refundable credit, which means that whatever tax is due on a quarterly basis for Medicare, the 1.45%, if your premiums exceed that amount, you get a refund for that excess. And so this will be obviously covered more in guidance later, but this is similar to the paid sick leave and family leave credit and the procedure that's in place for claiming that credit. And so we expect that it will be very similar. This is a deemed deposit of payroll tax. You're deemed to have made the deposit of whatever your premium is on the first day of the quarter. So there's no penalty for failure to deposit. You claim the credit through your Form 941 on a quarterly basis, or you can offset your payroll deposit. So the monies that you would normally send in on a regular basis within the quarter can be withheld, or you can send them in and then make the claim at the end of the quarter with the 941 for the full amount. Now, for the procedure that's in place for the paid leave, Form 7200 allows the employer to get an advance and not have to wait for filing the Form 941. We think that probably will be also applicable to this procedure, but we don't know yet, and that will be explained in guidance, no doubt. So here's an example of that. It's a lot of writing for the simple example of you've got $10,000 in payroll taxes in a quarter, but you've provided $12,000 of a COBRA subsidy. So you either make your deposits and claim the entire $12,000 at the end, or you offset your deposit and claim $2,000 on your Form 941. And again, you're not going to be penalized for failure to make that regular deposit within the quarter. Next slide. So the overstatement of the credit is treated as an underpayment. And so if the employer overstates and gets an advance refund based on a premium that is erroneous, that's considered an underpayment, and the IRS has 5 years to assess that underpayment. There are limitations on the credit. The employer cannot double dip, so to speak, by using wages that are paid for qualified sick leave purposes that are also a credit against the Medicare tax, and also claim a credit under COBRA. I think guidance will provide additional mechanics as to how that limitation works. There are health plan costs that are built into the paid leave subsidy and the credit, but this generally requires you to pick one or the other. Paid leave is not COBRA, so we're waiting for guidance as to exactly how this will work. So more to come on that. And then finally, the credit is treated as income to the employer. The employer cannot claim a deduction for premiums paid without recognizing income to offset that deduction if it takes the credit. So that is to prevent a double tax benefit. So these are a few questions that have been raised, but there are no doubt many more. The first is, how will the suspension of the deadline affect these COBRA election requirements? This is still ongoing. I mean, the original suspension basically required the employer to use good faith and a reasonable standard for providing its election. But if this suspension continues to apply to a COBRA eligible recipient that is supposed to make a COBRA election, for example, that extended period within 60 days of receiving a notice, and doesn't, what does that mean given the provisions of 2021-1? How will that apply? How will these two, how will the legislation and this guidance interact? If that turns out to be the case, and in the previous example, the recipient waits and then makes the election later based on that notice, is the subsidy available retroactively? And then another being, you have this alternative option for coverage that is different from the coverage that you now have, and that's a 90-day election window. And so if you have a 60-day election window for coverage in the subsidy period, you have an additional 30 days. So these are miscellaneous questions that we have, but we expect that much of this will be provided in the guidance that is no doubt forthcoming. So employers should review terminations and reduction in hour situations with their employees to determine who is an assistance eligible individual, because the notice requirements are going to apply to those individuals, and they should be identified as soon as possible. Again, the notice has to be provided by the end of May. We're expecting forms shortly, and we're expecting guidance shortly, but the first step will be, again, identifying the AEIs that will need to get notice, so the notice can be provided promptly within that notice period required by the Act. As I say, we're expecting guidance very soon. If a third-party administrator is involved, an employer should coordinate with a third-party administrator to again identify who will receive the required notices and generate the notices.
Thank you, Liam. Very informational. So we've got a couple updates from Mark Knoth. Mark, are you ready?
Yes, I'm here. Hi, everybody. I'm really happy to be here. It's a beautiful day outside, out my window. I'm here in my office in Detroit, and I hope this will be the norm soon. I'm sure you're all looking forward to getting back to the office. What we know for sure is that, the workplace has certainly changed in the last year, and it probably will never be the same. What we have to look forward to are more changes in the workplace regulatory scheme with the election of Joe Biden. I've got a kind of a short time slot here today, so I'm really going to give a high-level overview of some of the issues that are occurring right now at the administrative level. There are changes underway, but I mean, we're really barely 2 months into this presidency. So the election of Joe Biden, along with the Democrat control of the House and a slim majority in the Senate, could have significant impact on the workplace. There is some legislation out there as well that whether or not it has an opportunity to pass will remain to be seen. It makes the issue of whether or not 60 votes will be required or 51 votes will be required a major issue. The filibuster issue is something that's going to have a big impact on what we see in labor and employment law. President Biden has stated an aggressive plan to reverse a lot of the things that were done under the Trump administration, generally viewed as pro-business, anti-regulatory. I sort of view it as a possibility of returning to many of the policies that were in place under the Biden administration. I want to talk today about the Department of Labor in addition to the EOC and the NLRB. Please move the slide. Okay, thank you. So at the Department of Labor, the U.S. Department of Labor, which is a massive, massive government agency, they control and advise and issue regulations regarding overtime, minimum wage, OSHA, unemployment funds, funding, and so forth, and also training. There's new leadership in place to sort of give you an indication of what's ahead for us. The current director is this gentleman by the name of Marty Walsh. He used to be the Boston mayor, but he's also originated in a trade union as a leader of a construction trade union. He's already stated an expectation of taking a very pro-employee stance. Who is proposed for the second in command at the Department of Labor has been in the news quite a bit. Maybe you've heard about this Julie Su. She was the labor director of the state of California for a number of years. And if you know anything about California, if you have operations in California, you know it's one of the most highly regulated workplaces anywhere. A lot of the new trends come in California. They try things. You know, it's very difficult to be in compliance in California. If Miss Sue is true to form, we may be seeing quite a bit more regulation over the next 4 years. Some of the issues that they're looking at, the big one is contractor status. And this is the question of whether or not a subcontractor or a temporary worker or someone of that nature is going to be classified as an employee. Under the Department of Labor, this has major impact. Independent contractors could be entitled to overtime, wages, minimum wage, and the like. So what happened was President Trump had issued a final rule making it a little easier to define a person, a worker, as an independent contractor. March 11th, that regulation was withdrawn by the Biden administration. We haven't yet seen where things are headed, but we think it's probably going to go in the direction of the Browning-Ferris case, which was a labor case, essentially said that if an employer has a right to control an employee, they are going to be considered a worker, excuse me, even though they're termed an independent contractor, they're likely to be considered employees. Next slide, please. The other issue is joint employment is on the forefront. Trump administration had relaxed the rule, limited the scenarios where franchisors, subcontractors, staffing firms, and affiliated organizations could be considered a single company that could be liable for employment violations. It looks as though that rule is going to swing back the other way under the Biden administration, although at this time we haven't actually had an opportunity to review that rule. The other big issue with the Department of Labor, I labeled it tipped wages, but it's actually minimum wage. As you know, there was quite a bit of talk in the last year or two about raising the minimum wage to $15 an hour. That was supposed to have happened in the Relief Act, but was not added, the most recent legislation. There currently are some regulations regarding tipped workers, and this primarily impacts restaurant workers. You know, the Trump administration had issued a rule that said that you could allow some people to do other work besides just tipped work and still be receive a sub-minimum wage. It looks as though the effective date of this rule has been delayed by the Biden administration, and we expect it to be scrapped. So there will be tip pooling enforcement and probably a return to the old rule as it relates to tipped workers. The Department of Labor is also focused on a virus safety rule. OSHA, throughout the pandemic, we've relied on the general safety rule under OSHA that says you have to provide a safe workplace, and then consequently relied on other regulations that were issued by the government from the CDC regarding that. The new rule hasn't come out yet. We expect it to model somewhat what has been in place here in Michigan. That's been stated that Michigan is a good example, so we have to wait and see, but certainly within the next several days, if not weeks, we expect to get a new safety rule under OSHA. Next slide, please. Equal Opportunity Commission has likewise changed in leadership. There's a new acting general counsel at the EEOC, Gwendolyn Young-Reams. She's a lifer at the EEOC. She will have a major hand in creating the strategic enforcement plan. Every 4 years, the EEOC decides what its priorities are and they put it in a plan. Under the Trump administration, that plan was very, very simplistic, did not involve much. There wasn't much to go on. Under the Trump administration, the EEOC was largely, focused on compliance. Under the new leadership, we expect it to swing back to more systemic enforcement, large organizations, getting case law imposed to, decisions out on new subject matter that will change the face of employment law. One area, of course, is LGBT protection following the Supreme Court Bostock case, where LGBT status was deemed a protected classification because of sex under Title VII. That case left quite a few open issues, including whether companies could use a religious type defense under all circumstances, and whether there are facility modifications required, male and female bathrooms, if that's going to be an issue. We expect further guidance from the EEOC on that. Next slide, please. The EEOC is focused on social justice issues with the advent of Me Too over the last year. Excuse me, not Me Too. Me Too. The racial issues, systemic racial discrimination issues are expected to be at the forefront of their enforcement activities. Sexual harassment, which has been a major issue over the last several years. There were some guidelines issued in 2017 under President Obama's EEOC. Those were never finalized or implemented by the Trump administration. We expect those guidelines to be issued. Another issue at the EEOC is something called the Crown Act. A number of states have become involved in issues involving discrimination based on hairstyles. States have passed various laws to enforce anti-discrimination in that area. There's some movement in Washington to that effect, and if it's not by legislation, it may be by case law. So that's something to watch out for. And of course, the EEOC has got a place in vaccine issues. So whether or not people can refuse a vaccine based on religion or disability will be addressed by the EEOC. Next slide, please. So it's actually called the National Labor Relations Board. Small typo on the headline there. I apologize for that. The National Labor Relations Board has been the subject of a ping pong ball back and forth, swinging of the pendulum between Democrat control and Republican control, made it very difficult to advise clients as to what's allowed and what's not allowed, because you're not knowing what's going to happen from one term to the next. The general counsel under Trump was terminated, refused to resign and was terminated, and a new general counsel was put in place. General counsel sort of sets the tone for the NLRB, even though the individual board members are independent and are going to be in place for some time. But upon being appointed, general counsel Orr rescinded about 10 directives immediately that had been in place under the Trump administration. What do we expect to see? Well, first of all, there's going to be a return to the handbook issues where non-union employers can be found in violation of the NLRA for certain policies contained in their handbooks. Social media policies, confidentiality, emails, bulletin boards, among others, are all going to be called into question yet again. Hopefully it revise your handbooks too dramatically from the Obama administration, but those are areas that employers are going to need to pay careful, close attention. The election rules are likely to be changed, a return possibly to the quickie election rules, which made it difficult for employers to mount a counter campaign once a petition was issued. Union access rules, can the union get on property of an employer to reach and campaign to try to organize? Those issues are expected to be addressed by the NLRB. Next slide, please. And of course, the joint employer issue, as I discussed under the Department of Labor, you know, they're going to try to combine organizations, companies that use staffing firms, subcontractors for organizing purposes. The same issue will apply. We expect that to be revisited by the NLRB. So the other thing, I'll end with this. There's some legislation that's pending in Congress. It's passed the House. It passed last week at a vote of 225 to 206. This is called the PRO Act, and PRO stands for Protecting the Right to Organize. The PRO Act is, by many opinions, would be one of the most significant changes to labor law since the 1940s. Over time, the National Labor Relations Act has been chipped away at by decisions, by modifications. This act seems to be attempting to move it back to the strength that the National Labor Relations Act had at an earlier time. Some of the things that would occur, in particular, the independent contractor and the gig economy would be greatly affected if the PRO Act is passed by the Senate. They would codify the new joint employer standard. It would make it much more difficult to classify workers as independent contractors. They would use something called the ABC test, which is one of the most difficult tests under which to establish independent contractor status. It would prohibit class action waivers, which is something that we've tried to get employers to put in place, even with non-union employees. It would prohibit right to work laws. There are currently 28 states that have right to work laws, allow people to not join a union if they choose to do so, which has greatly impacted the union's right to raise money, collect fees, and expand and organize. Workers would get a private right of action to sue under the NLRA. Right now, you have to go to the NLRB, but if an employer violated the National Labor Relations Act, say, for example, one of these handbook rules, they could sue in federal court for violation of the NLRA. It would also increase available damages under the NLRA. And so this is probably the thing I'm watching the closest, is in addition to the filibuster, whether or not that's withdrawn. But we have a very exciting 4 years ahead for us as HR professionals and labor and employment lawyers. Thank you very much for your time.
Thanks, Mark. A lot of good information there and definitely some potential changes coming up. We do have a couple questions. The first one goes to Liam, and it is, does the EE termed in October 2019 who elects coverage after April 1st, 21 have to pay retro premiums back to October 2019?
Well, probably not. I mean, it is a question. We don't have an absolute answer at this point, but the interaction between these notices which suspend election and this new subsidy in part is important, because if someone elected under the old notices after the typical election period, they could still elect COBRA, but it would be retroactive back to the qualifying event, and they would have to pay premiums back to the qualifying event. So this is a separate treatment. And my suspicion is no, because if they become entitled to this subsidy and elect coverage within the subsidy period, then they will receive the subsidy as of April 1, the first day of the subsidy period, and going forward, and not be on the regular eligibility period of 18 months. But there's nothing in the act that says that the election by way of this extended period will result in coverage back to the qualifying event.
Great, thank you. The look back period on this is 18 months, is that correct?
The look back period, I mean, in a sense, it's a look back period. It is essentially any former employee who could be eligible under the normal COBRA rules within the subsidy period. So the 18-month look back is really the outside. Anybody before that, if their qualifying event was June of 2019, they would be beyond that 18 months under the normal COBRA rules, and so they could not be a COBRA recipient within the subsidy period. So yes, essentially there is a look back period in that respect of 18 months.
Okay. Mark, I believe this question is for you. Do you see MyOSHA extending the rule requiring employers to have those employees that can work remotely do so?
I'm sorry, I missed that. I had a muting issue.
No worries, I'll repeat it. Do you see MyOSHA extending the rule requiring employers to have those employees that can work remotely do so?
My crystal ball, it's difficult to say. I think it's going to depend largely on what happens with the virus, the vaccine, and so forth. I do see that occurring. I think it's currently on the books until sometime in September, but who knows? I think it's a great question. I think everybody's waiting to see, but I think that it seems as though the governor's taking a very careful approach here to remote work.
All right. Thank you to Mark and Liam. And at this time, I'll go ahead and turn it back over to Scott.
Thank you, Rebecca. And thank you very much, Liam and Mark, for those insightful and timely comments, helping to bring more clarity around these changes and how they're going to impact those listening on today's call. Clearly, you have a strong command of these complex topics, which further accentuates the expertise of Kerr Russell as a firm and Liam and Mark individually as attorneys. So I encourage you to reach out to them if you're interested in learning more about their practice and how they can help your business with these and other employment related matters. Lastly, I just want to close that if some of you are wondering how and what the best way is to communicate these changes to your employees, you heard Liam discuss the requirements for notices and that there has to be particular information on those. Lovasco does have a strong communications acumen, and we would be glad to engage in a discussion with you to discuss how we can help you in that area as well. Again, I want to thank everyone on the call today for your time. In particular, I want to thank our featured presenters, Liam and Mark, for sharing your expertise and knowledge with us, and wish everyone a great day.